Good afternoon, everyone. Welcome to HHQ webinar. We are glad to have many esteemed attendees with us today for our webinar on safety and health in construction works. My name is Teo Zihan, pupil in Chambers of Halim Hong and Quek, and I will be the moderator for today's session. Before we kickstart this session, please be informed that all participants will be muted. And if there are any questions, please type in the Q&A chat box and we will discuss them during the Q&A session later. Please scan the QR code appear on your screen for attendance purpose. Please allow me to introduce our speaker, Mr. Ankit Sanghvi. Mr. Ankit's focus area of practice is in construction law, and he has handled significant assignments involving energy projects, engineering projects, and infrastructure projects for both local and foreign clients. Ankit's legal experience has enabled him to provide professional legal advice to his clients in respect of building and construction works in Malaysia from its inception right up to its completion. Ankit has conducted document review for clients, provided advice, and drafted agreements for employers, developers, contractors, subcontractors, vendors, purchasers, and tenants on various aspects of commercial, retail, and residential construction projects in Malaysia. So please join me to welcome our speaker, Mr. Ankit Sanghvi.
Thank you, Zihan, for that introduction, and a very good afternoon to the rest of you attending this session this afternoon. So, as you can see, the topic that we have on your screen is in respect of health and safety in the construction industry in Malaysia. What I will be covering this afternoon is specifically in regards to the legal perspective of the health and safety area of the construction industry. So without further ado, allow me to get onto my slides. And I will start by saying this. In the last couple of years, I'm talking at least the last 10 years or so, the construction industry specifically has accumulated a very high number of work fatalities. And by this, of course, all of you would understand it means deaths that are occurring at the place of work. So the general safety and well-being of workers, as we know, is something that must be safeguarded by employers. And specifically in regards to the construction industry, it is all the more relevant because there are a lot of hazards that are associated with the industry. And it is a duty on the employers, on the contractor, to ensure that the environment created is a safe environment. There are methods of work that are actually put in place and adopted at the construction workplace to ensure that the fatalities or injuries that occur at the workplace are reduced. We cannot possibly curb it entirely, but if we do have proper measures in place, then what we will see is a decline in the number of fatality cases and even injury cases. Now, if you look at the screen right now, what I have actually is the occupational accident statistics, which is split into by sectors for the year of for the year of 2020, actually. So for the whole year of 2020, what you can see on your screen is the fact that we had about 6,933 reported cases. Yeah, and when I mean reported, these are cases that are reported to DOSH. And DOSH, by the way, is the Department of Safety and Health in Malaysia. So from the screen, what you can see is, of course, the most popular industry, I would say, or the industry which has the most amount of cases is, goes without saying, is the manufacturing industry, where we had 4,202 non-permanent disability cases reported. We had 231 permanent disability cases reported. Permanent disability, as you would all know, simply means a disability which is prolonged for a very lengthy period. And finally, it has resulted in 73 deaths, which is the highest number of deaths for a particular sector. But if you look at the total number of cases for manufacturing, you would note that there were 4,500 cases. So if you take the number 73 and contrast that with the total number of reported cases of 4,506, it's actually, in terms of percentage, not very large. But if you look at the construction industry, it is a very, very significant percentage. We have a total of 206 reported cases for the year 2020, out of which 66 were reported death cases. So you can see the ratio or the percentage is significantly greater in the construction industry. Although the number of total cases are lesser, I am one who very strongly believes that this is because we do not have all top types of reports going in. Some people do not report cases, and that is why the number perhaps is not reflective of the actual number of cases. Now, if you look at 2021, which is the next slide on the screen, you will see that the construction industry, as it stands until June 2021, has already recorded 36 deaths, 77 non-permanent disability cases, and 6 permanent disability cases. So again, it's a very significant number. And as it stands, we are actually higher in the number of reported death cases, even if we compare it with the manufacturing industry, which is the largest number of injuries in regards to health and safety. So it is a very alarming rate that this is increasing at. So this session that we have today will actually cover various acts and legislations, some of the regulations as well that have been put in place that both, not just employers, but even contractors, subcontractors and so on, need to know and need to be aware about, because these are the very basic and fundamental health and safety laws that exist in the country as we speak. And whether it is in regard to precast manufacturing, or whether it's the quarrying industry, or whether it's a sand factory, ultimately all of these regulations and laws will apply. So as I mentioned, the two main legislations that we have in Malaysia is the Occupational Safety and Health Act 1994 and the Factories and Machinery Act 1967, which is a slightly older act. But the more important or the more prominent act is actually the Occupational Safety and Health Act, because it is a more general act in comparison to the Factories and Machinery Act, which is very specific. It's in regards to machines that are used in factories, particularly. So the OSHA, I will call it the OSHA for the rest of the session, which is the Occupational Safety and Health Act, makes provisions for securing the safety, health, and welfare of persons at work and for protecting others. So it's not just for creating safety for the persons at work, but for also to protect others against the risks to safety or health in connection with the activities of the persons at work. So it specifically provides that the construction industry is one of the many industries covered under the Act. So it is very relevant to the construction industry. When we speak about duties to the employee, Section 15 of OSHA actually covers the same. And it states that there is a general duty that is imposed on employers and self-employed persons to their employees to ensure, so far as practicable, that the safety, health, and welfare at work of all its employees are taken care of. So this is first and foremost a duty that is imposed upon the employer. And apart from the duty on your employees, you also have duty to persons other than your employees. And this is provided for by sections 17 and 18 of OSHA. And what it states is that the duty even extends to other individuals who are not its employee as follows. Firstly, to ensure that the conduct of the undertaking does not expose others to any risk to their safety or health. And secondly, to ensure that the premises and all means of access thereto and egress therefrom available for use by persons using the premises, and any plant or substance in the premises or provided for use there is or are safe and without risk to health. So what you can see is from these two provisions, the duty extends to not only your own employees, but also to other people who perhaps have access to the premises, who perhaps need to use a particular pathway to enter and exit out of the premises, or any plant or substance that may be required to be used, for example, asbestos or a particular type of chemical. All of these things are things which could affect not just your employees, but other people in your surroundings. So the duty goes on that far, and it would be a criminal offense, and a sanction would be taken against you if you have breached either one of these provisions. So this is, of course, a very serious provision, because it sort of widens the scope of who you are obliged or who you're responsible for. Now, Section 16 of the Act states that there is a duty to formulate safety and health policies at your workplace. And what it says is, if you look at the bullet point, there is a duty to prepare, and as often as may be, appropriate revisions are to be made to a written statement of the company's general policy with respect to the safety and health at work of the company's employees and the organization, and arrangements for the time being in force for carrying out that policy, and to bring the written statements, policy, and any revision of it to the notice of all of its employees. So this is actually what I call ongoing duty. The duty doesn't just stop at, I have created a health and safety written statement policy, and therefore I have complied with Section 16. No, it doesn't work like that. It is a continuous duty, and there is a legal obligation for you to ensure that appropriate revisions are made from time to time to ensure that your policy statements are in line and in tune with the current laws of occupational safety and health in Malaysia. So this is, again, important because it tells you that you have to actually do your written statements, do your general policies in respect of health and safety, and you need to ensure that it's always updated. And there is a penalty in the event you fail to do this. And that is provided under Section 19 of the OSHA. And it says that a failure to adhere to these basic requirements may result in a conviction or to a fine not exceeding 50,000 ringgit, or to imprisonment for a term not exceeding 2 years, or to both. So it is, again, a very serious offense in the event Section 16 is not complied with. Now, Section 29 of OSHA speaks about the safety and health officer. Now, an occupier of a place of work would need to employ a competent person to act as a safety and health officer at the place of work for the purpose of ensuring the due observance at the place of work of the provisions of the Act and any regulations made thereunder, and to promote a safe conduct of work at the place of work. Now, what this means is every place of work would need a person to be appointed as a health and safety officer. Amongst the categories of employers who are required to employ a safety and health officer are any building operations or engineering construction works where the total contract price of the project exceeds a sum of RM 20 million ringgit. Of course, if you fail to do this, assuming you have a contract where the value exceeds 20 million ringgit, but you do not have, or you have failed to employ a safety and health officer, you would be, again, penalized for it. And a contravention of it would result in a conviction or to a fine not exceeding 5,000 ringgit, or to imprisonment for a term not exceeding 6 months, or to both. So again, this is an offense for larger projects which exceed the sum of 20 million ringgit. A safety and health officer would not be required in every type of industry, but suffice to say, if it is in relation to building operations or engineering construction works, and the value exceeds 20 million ringgit, you must have a safety and health officer appointed. Now, what are the regulations that govern the duties, the functions, the obligations of the safety and health officer? And this is provided for under regulations 15, 16, and 17 of the Occupational Safety and Health Regulations 1997. So bear in mind, these are the regulations. This is not the act, but it specifically provides that an employer shall provide the safety and health officer adequate facilities, including training equipment and appropriate information to enable the safety and health officer to conduct his duties as required under the act. Now, this simply means that it is not just suffice for the company to appoint a health and safety officer and leave it at that. It is actually a duty or a legal duty under the regulations for the employer to provide adequate facilities to ensure that there's proper training that is given to the health and safety officer, and all necessary information is given to the health and safety officer for him to actually properly run his functions. You must actually, the employer must legally permit the safety and health officer to at least once every year to attend any continuous education program to enhance the knowledge of the safety and health officers' knowledge in regards to occupational safety and health laws. So this is a legal obligation that requires the employer to send his or her safety and health officer to any education program. It could be a seminar, it could be something, but you need to actually have records of this. It's no point just attending these things and complying with regulations without actual proper record. But what needs to be done is to basically collate all this information to ensure that in the event the authorities come and check on you, you have actually complied with these provisions. Now, the employer shall also direct one supervisor or who has direct control on person or activity of the place of work to assist the safety and health officer in any investigation of accidents, near-miss accidents, dangerous occurrences, occupational poisoning, or occupational diseases. So the safety and health officer doesn't work on his own, but there is a supervisor who would also be somewhat keeping a check and balance on the functions of the safety and health officer, and he will assist in other matters such as investigations which need to be carried out in the event there is some accident or a near accident that perhaps had taken place at the place of work. Now, sections 30 and 31 of the Act states that every employer shall establish a safety and health committee. Remember, just now was a safety and health officer, but now section 30 and 31 require a committee to be established at the place of work only in specific conditions. And the condition is that if there are more than 40 people employed at the place of work. So of course, for Country Garden, I think this would be applicable because in most of your places of work, you are likely to have at least 40 people or more working. So there is a legal obligation to ensure that a committee is set up in this kind of situations. And the functions of the committee would be to keep under review the measures taken to ensure the safety and health of persons at the place of work. Secondly, to investigate any matters at the place of work which a member of the committee or a person employed at work considers or has reported the incident to. They must attempt to resolve any matters referred to above, and if it's unable to do so, then they must request the Director General of the Health and Safety Department in Malaysia to undertake an inspection of the place of work for that purpose. So this is the key functions of the committee which is to be formed under sections 30 and 31 of the Act. Now, two other functions is that the employer shall consult the Safety and Health Committee with a view to make and maintain arrangements which will enable the company and its employees to cooperate effectively in promoting and developing measures to ensure the safety and health at the place of work of the employees, and to ensure that the effectiveness of such measures are in fact carried out. So this is again what we call a check and balance mechanism, where it is not just simply about creating the committee, but it is to ensure that the employer has a role. They consult the Safety and Health Committee and ask the Safety and Health Committee what things need to be done, and they basically take on board suggestions, improvisations, newer policies that need to be put in place, and so on. Now, and if a failure to actually do so can result in conviction or to a fine not exceeding 5,000 ringgit, or to imprisonment for a term not exceeding 6 months, or to both. So as you can see, the penalty provisions are quite similar, except that the imprisonment term or the value of the sum sometimes differ. Now, the next act, I've highlighted some of the key provisions under the OSHA. Now let's look at the Factories and Machinery Act 1967. Now, the Factories and Machinery Act, which I have used the words FMA here on, it governs the control of factories with respect to matters relating to the safety, health, and welfare of persons. So this is specifically in regards to factories, not just construction sites and so on, which is what OSHA would be relevant for. But the duties of the occupier is provided under Section 21 of the FMA. And duties of occupier simply means the person who's occupying the premises. Doesn't mean the owner or the landowner on the title, but who is the person occupying it, who's in control of the premises. Now, Section 21 states that whoever that occupier is, he shall maintain all safety appliances and machinery. That is his responsibility, since he is the person in charge of the premises. Section 35 of the Act, Factories and Machinery Act, deals with building operations or works of engineering construction. So this is relevant to the construction industry specifically. And it states that every person who undertakes any building operations or works of engineering construction shall notify the Department of Occupational Safety and Health, which is what we call DOSH, not later than 7 days from the commencement of construction activities. However, you are exempted from this requirement in the event your construction activity is something that can be completed in a period of less than 6 weeks, and it does not involve the use of machinery. However, if the moment there's machinery involved and it exceeds 6 weeks, and it is a form of engineering construction works or building operation works, then you must, within 7 days from the commencement of your activity or works, report it to DOSH. Now, looking at the regulations, the Factories and Machineries Building Operation and Works of Engineering Construction Safety Regulations 1986, bear in mind, these are the regulations, not the Act. I want to highlight specifically Regulation 25, which deals with site safety supervisors. Now, it states that the main contractor of a work site, please bear in mind, this is the main contractor, not the subcontractor. The main contractor of a work site shall appoint a part-time site safety supervisor who shall spend at least 15 hours per week exclusively on safety supervisions and on promoting the safe conduct of work generally within the site. The site safety supervisor shall ensure that the provisions of the Act and any regulations made thereunder are complied with and promote the safe conduct of work generally within the work site. So you can see from here that Regulation 25 is a requirement on the main contractor to hire a part-time safety supervisor who only needs to actually work 15 hours per week. But this requirement is something that is imposed on the main contractor. Regulation 26 talks about contractor safety supervisors. Now, this applies to people other than the main contractor. As you would note, Regulation 25 was in respect of the main contractor. Regulation 26 is in respect of every contractor other than the main contractor in charge of the worksite who employs more than 20 persons to carry out work on a worksite shall appoint a part-time contractor's safety supervisor who shall spend at least 5 hours per week exclusively on safety supervision and on promoting the safe conduct of work generally within the site. So you can see Regulation 25 and 26 are similar. The only difference is that Regulation 25 specifically deals with the main contractor. Regulation 26, on the other hand, would deal with the other contractors. There's a difference in the time per hours, the amount of hours per week that is required. As you can see, for the main contractor, it would be 15 hours, whereas the person or the contract safety supervisor that the other contractors appoint would only have to actually spend 5 hours per week. But please bear in mind that this is only relevant if the contractor has employs more than 20 persons. Yeah, so if you have 15 or less than 20 people working, then Regulation 26 would not apply. Now, Regulation 27 talks of the safety committee. So similar to the Act, which is the OSHA Act, the pharma or the factories and machinery regulation also contains something similar. And it states this: the main contractor of a work site, which means work site in this case, of course, is the factory itself. Yeah. So the main contractor of a work site in which 50 or more persons are for the time being employed, whether by him or by other contractors, shall establish a safety committee on which both employees and management are represented for the purpose of keeping under review conditions in the worksite which may affect the safety and health of the persons employed therein. So again, this would only apply in the event the threshold of 50 or more persons are hit. So if you have more than 50 persons, then Regulation 27 would be relevant for the main contractor on the worksite. And he must establish, similar to what we have in the OSHA, what we call a safety committee, which consists or constitutes of representatives from both sides, from the employee side and also the management or the company side. Now let's look at the Department of Occupational Safety and Health. In addition to the main legislations above, which we have dealt with, DOSH also from time to time issues guidelines in relation to safety and health issues in the construction industry. DOSH published something called the Best Practice on Occupational Safety and Health in Construction Industry 2019, which applies to all places of work in the building operation and works of engineering construction activities in Malaysia. And it covers OSHA, the FMA, and all its regulations made under the Act. The main aim of this best practice guide actually is it aims to provide guidance to construction management teams and on good work practices that can be carried out on every activity in the workplace to prevent accident to the workers. I highly recommend all of you to actually look at this document. You can simply Google it and it will come out. It's a 300-over-page document, but it actually tells you about every type of construction or engineering works, whether it is working from height, whether it is at a sand factory, or whether it is simply some other form of works that go on in most construction industries. They tell you and they specify what are the steps that you should take to ensure that you have proper measures put in place to ensure to avoid any misdeeds or injuries at workplace. Now, accidents and injuries are, of course, the most common thing that we try and avoid when we talk about safety and health. So there are legal obligations for you as an employer to report any instances of accidents or injuries that take place at work. Now, Section 32 of OSHA, let's go back to OSHA for a while, states that an employer shall notify the nearest DOSH office of any incident, dangerous occurrence, occupational poisoning or occupational disease which has occurred or is likely to occur at the place of work. So please bear in mind that it's not just after occurrence that you need to notify DOSH, but the law says that even if something is about to happen, I don't know what they mean by that, because usually most accidents and injuries are not things that we can anticipate. But if in such a situation, you know, there's a hanging sort of thing going on or something, you need to, which is hazardous to the people at work, then you need to actually report it ahead of time. And then DOSH will probably give you some guidelines to like do certain things by a certain date to ensure that no injuries take place. Now, Regulation 71 of your Employees Social Security Regulations 1971, this is what we call SOCSO, states that an employer shall immediately after the receipt of notification of such injuries, complete and submit the accident report form to the department. So you have to do this immediately. As soon as the employer has been made aware of an injury to its employee, you must actually instantly report it in the accident report form to the under Regulation 71 of the SOCSO regulations. Now, Section 31 of the Factories and Machinery Act states that whenever any accident which either causes a loss of life to any person or causes serious bodily injury to any person, or causes bodily injury to any person so that the person is prevented from following his normal occupational work for more than 3 clear days, excluding the day of the accident, or where the accident causes serious damage to machinery or other property, or any dangerous occurrence takes place in any factory or in connection with any machinery, then the occupier shall report the accident or dangerous occurrence to the inspector having jurisdiction for the area in which the accident or dangerous occurrence has taken place by the quickest means available, and subsequently, with the least possible delay, report in writing to the inspector in the prescribed form the facts of the matter so far as they are known to him. Very long provision, but if I could just sum it up in a very short sentence, it simply means that if any of those incidents in paragraph A, AA, B, or C occur, then you must actually report it to your police station, to your nearest police station in the fastest possible way. And as soon as you actually are able to set out the relevant facts of the matter, what time, when it occurred, how it occurred, then you put all of this down and you actually provide it to the inspector who is running your station or the police station in the vicinity of your workplace. Now let's look at some case studies. There have been, of course, fatal cases in the construction industry, and this usually results in prosecution by the Department of Safety and Health. There have been many fatalities at the construction sites despite steps taken by authorities. And I've cited a few cases on the screen. I will not name the companies or the parties involved, but in October 2016, a worker was struck by a falling hook block and load at a construction site in KL. The wire rope of the tower crane broke and caused the hook block to fall and strike the worker. This caused the worker to suffer severe bodily injuries, which led to his death. Just before that, actually, September 2016, quite similarly, we had a worker fall from height at a construction site in Penang. The worker was walking on a wooden plank towards the adjacent scaffold and accidentally fell. Due to the height of the fall, the victim succumbed to severe injuries and died. Now, it does sound like as though the worker may have actually had a contributory role in being negligent in falling, but it says that the contributing factor in the accident was that there was no working at height safe procedures established. So you see, this employer ultimately would have got into trouble because he didn't have in place safety procedures established for working from a very high place. If he had such measures and if the employee chose not to follow it and then fell down, there would be no issue. There would be no prosecution against the employer. But when you don't have this kind of procedures in place, that's when you usually fall into trouble. Take another case in May 2016. A worker was buried alive due to a landslide as he was installing formwork boards on the trench wall at a construction site in Sarawak. While he was working, the landslide covered and buried him, causing him to suffocate by compression. Now, what was revealed as a result of that was that the work was conducted without safe operating procedures for working inside trench. So working inside trench, just like you have working at height, there should be procedures for working inside trench that should have been put in place. And there was no hazard identification, risk assessment, or risk controls conducted prior to the commencement of work. Simply put, to draw a comparison with the earlier case, if these measures were put in place, then perhaps there would be no prosecution against the employee, even if there was an injury that had taken place. So it is very important that you do have actual safety procedures put in place. You have a safety and health officer who's aware and who's competent to deal with this type of areas. And like I said, each sector can have their own safety procedures, because obviously different sites may require different types of measures put in place. So DOSH has aggressively prosecuted construction companies for violations of the OSHA. And here are a few examples that I'd like to cite. In October 2016, a construction company was charged under Section 17, subsection 1 of OSHA, which requires the employer to conduct his undertaking in such manner as to ensure, so far as is practicable, that he and other persons, not being his employees, who may be affected, are not exposed to health or safety risks. The company was fined 5,000 ringgit for not establishing a safety system of work. I know the penalty is very, very low, but this is 2016. The trend actually has seen an increase in the type of fines that are going up, because some of it actually have a $50,000 limit. And I think more than the money, it also has a potential imprisonment penalty, and it puts your directors at risk, which is something, of course, everybody would want to avoid. So September 2016, a construction company was charged for 3 offenses under Section 10E of the Factories and Machineries Act. And this is because there was failure to install a sturdy fencing at the working level to avoid persons from falling, failure to provide safety measures while performing roof works, which includes usage of safety harness and safety belts for work above 10 feet in height, and failure to provide safety measures for plastering jobs, which includes the usage of safety harness and safety belts for work above 10 feet in height. Sorry, those are 2 repeated points. But the company was fined a total of 21,200 ringgit for these 3 offenses. In April 2016, a fatal accident occurred at a construction site, and the scaffolding structure collapsed on top of 2 workers, and they died on the spot due to severe injuries. This company was fined 20,000 ringgit under Section 17, subsection 1 of OSHA. So as you can see, the Department of Safety and Health do actually carry out prosecutions, and although so far what we have is a lot of it are just fines, I wouldn't be surprised if they actually take more serious and more penal punishments in the future. Now, best practices for mitigating occupational health and safety risks. So this part of it is really to actually allow all of you here to understand what are measures that should be put in place, what are good measures that companies can put in place to ensure that we can avoid, as far as possible, health and safety related incidents. Now, the key objectives is, of course, as any employer would say, is to ensure the duty of care for the employees. Secondly, to prevent loss of lives. In fact, actually, that should be the first thing. And finally, safeguarding your brand itself or your reputation of the company, because you do not want this kind of news to be publicized in the press or anywhere for that matter, if there is, for example, a fatality or someone dying in your workplace. So applying best practices and standards to construction sites enable companies to have appropriate preparedness in mitigating occupational safety and health risks. It's to ensure compliance with both statutory and common law obligations. It allows you to build trust and promote a feeling of safety, which motivates employees to be more productive. It also allows you to prevent financial loss due to lost time injuries, costly management of medical cases, and negligence claim. It allows you to safeguard your brand reputation, which I've already touched upon earlier, and it allows you to be an employer of choice. So putting good practices and standards in place in your company actually benefits not only your employees, but indirectly it will also benefit you, the employer. Now, an employer's duty of care to their employees includes taking all necessary steps which are reasonably possible to ensure their health, safety, and well-being. Now, this word reasonably possible is something that we take from the Act itself. They use the word reasonably possible. So the duty is really for you as an employer to just ensure that you have sufficient measures in place to ensure that anything that is possible of happening, any injuries that are capable of occurring, are covered by you, or there are measures put in place to ensure those events don't take place. If something completely unimaginable happens at your workplace, then as an employer, maybe you may not be responsible because it was something that wasn't even something that anyone could imagine. But everything else, working in heights, it is very common. Those measures must be there. And we have cases, we have seen DOSH prosecuting people for it. So ultimately, you need to have measures for at least those very basic things put into place. Now, employers also, of course, have a moral and ethical duty not to cause or to physical or psychological injury, and they must, of course, fulfill these responsibilities with regard to personal injury and negligence claims. It is important, obviously, for companies to seek professional advice prior to commencement of a construction project to avoid delays and penalties and costly rework. So the characteristics of a successful employer's duty of care. How do you actually achieve it? Few of these bullet points actually are really just key points I want to highlight, but actually having clear job descriptions for employees is one very important measure. Having clear internal safety and health policies, undertaking risk assessments and creating and updating risk registers, and creating a safe work environment, providing adequate training and feedback of performance, ensuring that staff do not work excessive hours, providing areas for rest and relaxation. This is something that I do see in quite a few sites. Protecting, so that this actually avoids people from having a cigarette in the middle of a construction site and so on. You actually have specific zones or specific spots to carry out these activities. Protecting staff from bullying or harassing, or harassment from internal or third parties. Protecting staff from discrimination, providing communication channels for employees to raise concerns or grievances, and providing employee assistance program, which is the EAP. So you can see from here, a lot of it, you might wonder, how come this providing staff from discrimination doesn't relate so much to health? Protecting staff from bullying doesn't relate too much to health or safety, but it does actually, because when we talk about health, we're not just talking about the physical health, we also talk about mental health. So these are measures which actually would create a very good employer. So in implementing best practices to avoid health and safety risks, one should consider the most effective mitigation is to actually of potential medical cases on site, because if you are likely to have injuries on site, how do you deal with that? So set up an on-site medical clinic. This is something that has been recommended by many professionals. Setting up an on-site medical clinic is not the easiest thing, because firstly, you would require registration and licensing from the Ministry of Health under the name of a qualified Malaysian doctor. And the clinic and design has to strictly comply with the specifications of the Ministry of Health. So it is not easy, but it is very doable, and that will be covered in this slide. So the factors to be considered in planning an adequate medical facility on site is, firstly, you need to consider the number of employees that you have working on site. Secondly, the remoteness of the site and the distance to the nearest local medical facilities. Third, the standard of healthcare at these facilities. Fourthly, distance to the nearest center of medical excellence. Fifth, appropriate medical transportation options are available. And sixth, type of operations on site, whether high, medium, or low risk. So these are just some factors that you may want to consider when deciding on whether or not you require a medical facility on site. Obviously, if you have your nearest hospital, say, is 3.5 hours away, then it is very strongly recommended that you do have a medical facility on site. And you must also have other measures which work hand in hand with that, which is what happens in the event, because your medical facility may be a very basic one and you won't be able to treat very serious injuries. Then in such cases, you need to have all this information at hand. Where is the nearest hospital? How long would it take to get there? And how would you get your injured employee to the hospital? Because sometimes if you wait for an ambulance, it might be too late. Simply put, because your location is in such a remote area, it might take quite a while before an ambulance reaches. So these are factors that you will need to look at. The factors that I've just mentioned, of course, will then determine the following things: the number of medical personnel that is required, the medical qualification that is needed. It depends on the type of common injuries that usually take place, the type and quantity of medical equipment, drugs, and consumables according to their risk, logistic considerations for medical evacuation, the need for a centralized response center to coordinate all these activities, drug and alcohol testing on site, fitness to work assessment, and first aid training. So if we have all of this information, it really sort of actually allows you to set up the medical facility in the most effective way. Whether or not you need 2 medical personnel or 10, it depends on the size of your project. What type of medical equipments that you need, again, depends. You would need the most basic equipment, but sometimes, depending on the nature of the works, you may also want slightly more complex medical equipment. The types of medications that are available on site as well are all things that are considered to be best practices to avoid occupational health and safety risks. Now, preventing programs should be developed and implemented. So what are preventing programs? Preventing programs are specific programs that are designed to actually avoid specific types of incidents. So for example, if you look on the left column, road accident fatalities, what you would want is safe driving practices and awareness. You've got trucks coming in, big trucks, small trucks, all of it. Have regulations, put speed limits within your site to control this kind of things. Communicable diseases. So what is required here, or preventive programs that would help, would be things such as employee education, mosquito bite avoidance, and selected chemoprophylaxis or recommended vaccinations. Environmental hazards, to ensure that the health, safety, and environmental induction programs for all workers prior to arrival on site. This is very important. A lot of companies already have it, but basically you go through an entire induction process on health and safety before you actually start work on the site. Mass casualty incidents. This is not very common, but it's good to have in place because sometimes you might have some very, very serious type of situations. Then you need to have this kind of measures in place, programs which allow you to develop a medical emergency response plan or mass casualty incident preparedness. So these are basically steps that you would want to take listed in this program of what you would do in the events, say a crane falls and 30 people die in the workplace. Of course, we don't want ever to hear of such an incident, but in such cases, you need to actually be a lot more prepared than just being barely prepared. And a medical emergency response plan, which sets out everything that needs to be done, will help in that situation. Now, I am coming to the last slide. In conclusion of today's session, I think we can gather that health and safety is, of course, very important, especially in the construction industry, considering the number of fatalities we have seen in the last 2 years. Records have shown that the companies that perform poorly in safety and health will often be prosecuted by the authorities. So it is absolutely and entirely crucial that construction companies, whether the developer or whether the contractor involved in the project as a whole, should put safety and health as one of its core values and one of its most fundamental duties. Thank you very much. And I will take any questions that you all have after this. Thanks.
Thank you, Mr. Ankit, for the enlightening sharing. I'm sure it is very helpful to many, especially our attendees today. Now we have come to the Q&A session for this webinar. You may post your question in the Q&A chat box if you have any question. All right. You may also click the raise hand button and we will allow you to verbally ask questions to our speaker. If there's no more question, please scan this QR code to give feedback on our session today. Dear participants, our next session is the assessment session. Please scan this QR code for the questions and also please submit your answer within 10 minutes. I believe that's all the time we have today. This marks the end of our webinar. Thank you very much for joining us. Thank you, Mr. Ankit.
Thank you, Zihan, and thank you everyone for attending. See you all again soon. Bye-bye.